It's completely a stay. I am repeating, Malas, I was there for 3 hours and 2 days, Malas. Only Nawab was arguing. Only Nawab was read. Now you can today say anything, Malas. And possibly, Malas, there are video recordings of the hearing. It was argued in the evening, Malas, till 9 o'clock. The learned judge sat from 5 o'clock. I mean, we can disagree on Nawab, but we should not say that Nawab is not the basis of your case. This is highly troubling. This is wrong. This is not the tradition of this court. Now, your lordship has extended the stay for filing, the time for filing reply, the only effect of which is the learned speaker's hands are tied. He can't do anything. And then the judge says, the learned order says, in the interim, and then he says, I am hearing it on Monday. This was a Thursday or a Friday. Next Monday I am hearing it. This will take care of it. But kindly go further. Kindly go further. Now your lordship has seen 167. Now come to 174. D. So your lordship is having, whatever your lordship makes of this cocktail of suppression, of misstatement, and of nabab. Whatever your lordship will see in the overall picture. D. D for Delhi. That was suppressio vera. This is suggestio falsa. This is a direct affirmative suggestio falsa. Because of the disqualification proceedings initiated against the petitioner is invalid and against the various provisions of the Constitution, as the resolution for removal of Deputy Speaker is already pending for decision, and the disqualification of the petitioner is liable to be set aside solely on this ground. Just because this is Supreme Court. Just because it suits you, you can't say today that it did not have any role, rejected. Over. Finished. That's not your case. Then 193. 190. And I hate to say what the bench would have said or held had this been told to the bench. That's not for me to speculate and possibly not for lordships to speculate. Now see the prayer. Nabam was not the basis of our case. Nabam was hardly argued or touched upon. Nabam was one out of many. Now see the prayer. The first prayer again, like that first ground. Issue a writ of prohibition, mandamus or any other appropriate writ, direction or order directing R1 to not take any action on the disqualification petition under Rule 6, seeking disqualification of the petitioners under so-and-so, pending before the Honourable Speaker state, and not to take any action on the same. Mark the 2 lines. Until the resolution for removal of Deputy Speaker is decided. Yes. Again, of course, that it is. Now see that written submission, which is filed now. Now meaning to oppose the reference to Nawab Rabia. Can you show me that? That is called written submission on behalf of R4, opposing the reference to a bench of 7 honourable judges. Possibly filed before 10 January, I am told.
There are 2. One.
Yeah, it's there.
Serial number?
Serial number D.
Indeed. After both the parties.
What is serial number?
There are 2, Mr. Dr. Singhvi.
There are serial number is called D answer.
One supplementary and another is only the first one.
In the first one.
Okay.
It's
then
called D. That's right. D1. Para 3.
Okay.
After hearing, may I read one?
Which one?
3. Para 3 in this written submission, which is under D. Page 3, para 3. After hearing both the parties at length on various arguments, including but not limited to the judgment of this Honourable Court, of course, other things must have been said, but the point you thought fit to mention was only Nawab Rabia here. That's your prime point. That's your showpiece. Including but not limited to the judgment of this Honourable Court in Nawab, the division bench of this court as an interim measure extended the time to file the reply to the summons notice of disqualification solely in compliance with the basic principles. This is the stay also. This is the stay. You moment your lordship knows, direct or indirect by any means, your lordship disables the speaker from passing an order X or Y on disqualification. That is a temporary stay. And nobody will question the Supreme Court. Nobody will go ahead after your lordship says, I extend the stay. The court says, no, there is no formal stay. Therefore, I will go and decide the disqualification. Without time. That cannot happen. Your lordship knows that. So that is my first point. On reference, it is of direct relevance. The Honorable Chief Justice put that question squarely, that please do only tell us about reference. Absent an agreement with all forms, all facets of Nabam, Your Lordship would and must with great respect refer it. Distinguishing it, Your Lordship has heard enough arguments, is not the correct course of action, is not going to really, it might generate more future litigation than solve any problem. Your Lordship would either, in a binary sense, agree or refer. And agreement, according to our side, is not possible for the variety of reasons given respectfully to Your Lordships. Now, the second aspect is, Your Lordship has been taken a lot into this 7-day, 14-day notice of intention, actual removal. That's a valid point. But it should not be thought that the reference, as and when it is decided, if made by Your Lordships, is on a singular point of working out these days or the stage. The reference would raise significant issues, and one of the...
Have you formulated the issues with Dr. Singhvi?
Well, it's not in this writing form. I'll give a one page.
Try that.
Give a one page.
You can try it right now. Because
Yes.
now.
There are many issues, but the core issue would be. No, I'm just saying, in the light of the argument that 7 days or 14 days can be harmonized. Your Lordships can hold on notice of intention to remove or the sitting. No, Your Lordship would have to decide the larger core issue.
Correct.
Which is 7-judge bench deserves to decide.
It's not just
whether Your Lordships can directly or indirectly conflate Chapter 3 and 10 schedule. Or to be more precise, 179 to 182, etc. and the 10 schedule. What is the chapter? We are not saying this is the only issue. I don't misunderstand me. I am on the Nabab area point. There are many other issues. Tomorrow it will be said that I am giving up all other issues. No. On Nabab area, the issue is not about days and time and sitting. Now, why it has already been said, so I will not repeat this, but just note in bullets why this conflation is very dangerous, or at least has to be decided. The heart of the error of Naban is a conflation, a mix-up of two distinct. One, I'm giving in bullets the reason. One, not only Kyoto, but starting from Kyoto, case after case after case, constitution bench after constitution bench said, 10th schedule is a code in itself. This has been forgotten. CODE is repeated everywhere. Code in itself. Self-contained autonomous code. This word is very important, Malaz. So, Malaz, it's an impregnable, self-contained code. I made the point indirectly about notwithstand and subject to. But it's a code. That's Kyoto starts with Kyoto, it says it's a self-contained code. So, there can't be a conflation like this. Two, there is a continuity envisaged in 10th schedule, even if a lot of adventurous action is happening in the rest of the constitution. With the speaker. The para 6.1 which Mr. Sibal read, the proviso, illustrates two things. There cannot be a hiatus, stoppage or lack of continuity in 10th schedule. Malas, they have gone that far to anticipate that he is the speaker. This speaker, Malas, will have a disqualification against himself because he has done some untoward act. And Your Lordship has used another phrase, persona designata. Normally, in the 10th schedule, the persona designata is the speaker, and a persona designata means no one else by exclusion. That's the meaning of a persona designata. They anticipated and said, yes, it is a persona designata. But what in the strange case where I myself am facing a disqualification? No stoppage, no lack of continuity, no hiatus. Anybody else will be elected and will become the speaker, so-called, for the 10th schedule purposes. That's proviso to para 6 bracket 1 of the 10th schedule. The third reason you can't conflate, because of the whole idea is continuity. The third reason is that, it was said, Mr. Sibal did say, but I want to elaborate on that there is no 10th schedule of the old kind, now only defenses. Now, Your Lordship may not have looked this time, but earlier Lordship saw. 4, 5 and 6 are very interesting clauses. The defenses are very limited now. 4, 5 and 6 are the only defenses. As my Lord knows, there was 3, which is conspicuous by its absence by the 91st Constitution Amendment of 1104 that deleted clause 3, the split. Now just see the nature of the defense, fellows. 1, merger. I'll not read it. That's clause 4. Now, merger, fortunately for all of us, is not even alleged or pleaded or claimed by them. Forget your lordship finding merger. It is not their case. Second exemption is, well, it's a kind of a sympathy condonation. If he rejoins, there are cases where the person will rejoin. So you have a provision by which he can be let off. That is fine. And six, actually it's only 4 and 5. Sorry.
Only 4
4 and 5. 3 was there earlier. Sorry. Now, that brings me to the fourth bullet under this. What is the purpose of this? Well, as your lordship will read Mr. Ashok Sen's speech when 85, this was brought in for the first time, 10th schedule. Well, he said all this constitutional sin, stigma, purity, all that is there in that speech. That had happened, Malus. There were 2 actual names of actual MLAs in Haryana in 1967. These are the names of actual 2 MLAs. That's how this phrase has occurred. Now, he cites all that. Then your lordship has these amendments to delete. The object is that defection is a per se doctrine. Defection becomes a per se doctrine because you give highest weight to maintain purity. Well, as your lordship is with respect thinking of a very, very unique, extreme case. It will be academic, it won't happen in politics. Of everybody leaving except the chief minister and the speaker. Theoretically, it can happen. But well before that, everybody will leave, including the speaker, or he'll be removed, as Sibal said. So it doesn't really arise. It will not, it should not come into your lordship's analysis of how to deal with this Nabab issue. The object is that as long as even the majority or large number or small number, minority, split, anything goes, we bring it straight, because we have found from 85 till these amendments came that the split and so many other defenses were being used. So, therefore, it's a per se doctrine. In a per se doctrine is the 5th bullet. The speaker has to get only 2 things, Kindly note that. What does he have to get? Why? He has to get, any evidence of voluntarily giving up or voting or abstaining. They're the only 2 categories. Now, second is easy. There's a whip to be shown. You absented yourself or did not vote. The first one is, your lordship is interpreted in 10 judgments by conduct, by going to the governor, by being photographed on a podium with giving speeches with the opposition. All the judgments are there. So the speaker must act if the 10th schedule is a constitutional sin prevention. Your lordship cannot allow the other side to ask him, you can act, but you may be biased. May be biased. So that's my second point. My third point is, this alacrity point. And I'm not on the general point which your lordship asked, but on the particular point which both the Chief Justice and Justice Narasimha asked, on the notice period. Your lordship said they may have some relevance to what is the notice period which the speaker gives. Now there, just for the record, your lordship asked that question. Just note down this and then I'll give your lordship. There are 3 judgments which are very important. Lordship, note down, then I'll give your lordship. One is Ravi Nayak. It's a division bench from Goa. 1994 Supplementary 2 SCC 641. PDF 191 of the CC1 case law compilation.
Supplementary 2 SCC page.
94 Supplementary 2 SCC 641. It starts as your lordship's compilation of cases as PDF 191. And the relevant part is para 24 at PDF 204. Don't go to it, just give me a minute. Don't go to it now. The second judgment is Yedurappa, which is not in any compilation that I know of. Just note the citation, need not go to it. 2011, 7 SCC, page 1. Both of these, Ravi Nayak and Yedurappa, are division benches. Both are division benches. The judgment I'll take your lordships to, which covers these 2, is Shrimant Patil, which is 2020, volume 2 SCC 595, PDF starting page 1249 and relevant paras are 109 to 112. The ratio is in 112 and the PDF page is 1292. Now note, Police, 2 things before I read that last judgment only. Goa, which is Ravi Nayak, has a rule of 7 days. Goa has 7 days. Both the Karnataka judgments, Yedurappa and Shivan Patil, also have 7 days.